conflicts of interest under the American Bar Association rules. What qualifies as a conflict of interest under legal ethics rules is broadly defined. No other interests of the attorney can be allowed to interfere with the loyalty to the client. A conflict can come from the lawyer's own interests, those of other clients, former clients, and third parties. And the rule applies to the whole law firm, not just the individual attorney. Lawyers practicing in the same firm are considered one for the purposes of conflicts of interests. A conflict exists if another client of another lawyer has contrary interests, if the two attorneys work in the same firm. If it would create a conflict, the attorney must refrain from taking on a new client. This is why attorneys run conflict checks involving a large database of clients in the larger law firms. If a conflict arises with an existing client, the attorney has a duty to withdraw from representation. The rules are designed to create a client-attorney relationship focused exclusively on protecting the interests of the client. Anything impeding with the attorney's abilities to exercise independent legal judgment on behalf of the client is a conflict of interests. When the client is a corporation or other form of organization, the client is the corporation or the organization itself. The client is not the CEO, the board of directors, the shareholders, or any individual stakeholders. In order to avoid conflicts and confusion, when a lawyer is providing legal advice to one of the staff of the company, the attorney should make it clear that the attorney represents the company, not the individual. To further avoid confusion about roles, the attorney should avoid taking a position on the company's board of directors. The attorney owes a duty of loyalty and is required to protect the organization. According to the American Bar Association, in order to prevent substantial injury to the organization, the attorney may report employees to management. If management does not resolve the matter, the attorney can report outside to the appropriate authorities. This involves a situation where the employee, officer, or agent plans a criminal course of action or other actions that could substantially injure the company. The Sarbanes-Oxley regulations create mandatory duties for SEC reporting companies issuing and selling securities. An attorney aware of misrepresentation of financial reports or other violations of securities regulations must report such violations upwards in the organization. If effective remedial action forming an appropriate response is not taken by the managers, the attorney under Sarbanes-Oxley has a duty to report the matter to the chief legal officer in the organization and then out to the audit committee or a committee of outside directors. The attorney's responsibility is to protect the organization, and this may involve protecting the company from its own management and staff. A lawyer cannot represent two opposing parties where their positions are directly adverse. The lawyer cannot represent client 2 if the duties to client 1 materially limit his abilities to represent client 2. There is an exception allowing representation of two clients where potential conflicts may exist, when the lawyer obtains informed, written consent from both clients and the lawyer reasonably believes that dual representation will not materially limit the representation of any one client. With consent, an attorney can sometimes represent co-parties in criminal or civil litigation. However, an attorney can never represent opposing parties in litigation. Even after the termination of the engagement, the attorney's duties to the former clients continue. An example involves the attorney's duty to protect and not misuse the former client's confidential information. A lawyer cannot represent an opposing party to a former client if the lawyer holds confidential information from the former client and the information is relevant to the dispute or transaction with the new client. Alternatively, a lawyer cannot represent an opposing party to a former client if the matter is substantially related to the former representation. There is an exception allowing the new client representation where the lawyer obtains the informed, written consent of the former client. Interviewing with a potential new client can expose confidential and sensitive information to the lawyer. The lawyer has a duty to protect confidential information even without a client engagement. After interviewing with one client and exposure to confidential information, the lawyer cannot then represent another client in the same or substantially related matter. This applies to other lawyers in the same law firm. The whole firm is disqualified from representing anyone else in this matter or this case. So, a savvy prospective plaintiff may interview all the best law firms and thereby disqualify them from representing the defendant. There is an exception where written disclosure is provided to the client that interviewed with the firm, and the representation is undertaken by another lawyer in the firm. The lawyer that interviewed with the client takes steps to avoid exposure to the confidential information and is screened from the case.